Well, hello and welcome to Business 210, Business Law. And this online course is going to be a little bit different than a traditional class in that a little bit more responsibility falls on you, the student, to make sure that you go through the material in each chapter. Now, let's move on and talk a little bit about the course and a few other things I would like for you to keep in mind. First of all, make sure that you have read the syllabus and the syllabus amendments, which also contains what's normally called classroom policies. We don't have a classroom per se, but there are still some things in there that you need to be aware of. Why are we studying business law? I doubt that many of you or any of you are planning on becoming lawyers. Uh, so if that's the case, why know the law? Well, if you're going into business, there are a number of legal requirements that you are going to have to deal with. You will have occasion to deal with lawyers and legal paperwork and those sorts of things. Knowing what those things are up front will provide you a bit of an advantage in terms of conversations you might have with an attorney, with knowing the steps that need to be taken, with making business decisions. The choices of whether to open a business as a sole proprietorship, as a partnership, as a corporation, as a limited liability company. Each one of those choices has different ramifications, and your situation will vary, and your decision on which one of those to take if you want to start a business will have something to do with some of the material that we're going to learn throughout the course of this semester. Now, each week and each chapter, you will be having a homework assignment to brief a case. Yeah, that sounds kind of like law school stuff, but really, this is a writing assignment, and it helps to demonstrate that you're able to read and understand and summarize a legal case that, for the most part, these are either U.S. Supreme Court or state appellate court decisions that have had a significant impact on how the law is interpreted within the context of business. And each one will be focused on a case that has to do with the topic of a given chapter. Now, how do you write these briefs? Well, there is a specific format, and I do want to go through that with you just a bit and kind of get you up to speed. It's called IRAC and IRAC. And what it does is really just provides a template for you to pull your things together. And once you've done a couple of these, you'll see that the format is very simple. And these papers are not terribly long. They're going to be a page or two for the most part. So just what is IRAC? IRAC. Well, the I stands for what is the legal issue in the case. R is what is the rule, the law of the case. And then A, what is the court's analysis and rationale? And C, what is the conclusion or outcome of the case? Now, judges apply legal reasoning in reaching a decision in a case. It's a very tightly formatted process called critical legal thinking. And this case study briefing method we use mirrors that process. These legal terms are going to be useful in helping you understand the cases and much of what we'll discuss throughout this semester. First of all, we have plaintiffs and defendants, and these will happen at the original level of the court case, when the court case is first filed and first heard. The plaintiff is the party that institutes a lawsuit in the court, and the defendant is the party against which the lawsuit has been brought. Now, when we move into the appeals process, the rules may sometimes change and sometimes not. It really depends. I'll explain that. But first of all, what we have is the petitioner or appellant. That's the party that has appealed the decision of a trial court or lower court. And the respondent or appealee is the party who must answer the petitioner's appeal. Now, since most often an appeal is brought by whoever loses in the case, that is going to be the party that will become the petitioner in the case. And it really is going to depend on how the original case was decided. And then the opposite party becomes the respondent. So what will your IRAC papers look like? Well, let's run through the elements of a case brief. The first thing is a case name, citation, and court. Now, if you've taken other courses where you've had to write term papers, you know the concept of citation. That's identifying where you're getting the information. We're using a slightly different format here, but and here on the screen you can see what we're talking about. So, in this particular example, we are showing a case that went before the Supreme Court of the United States involving a professional golfer with disabilities who filed a suit against the PGA, which has a rule against using carts in PGA Tour events. Golfers are expected to walk the course. He was physically unable to do so, and he filed suit. So it becomes PGA Tour Inc. v. Martin. And the citation shows that it is, and you can read all those numbers, basically tell you where in the legal records this can be found. And in this case, it's sourced from the 2001 Lexis database, and then finally tells you that it's from the Supreme Court of the United States. The next step is to lay out some of the key facts, the basic background of the case, and it's done in kind of a shorthand style, bullet points as it were, rather than a long narrative. You're just looking to keep to the essential bits of information. In this particular example, it identifies the PGA Tour Incorporated, that is the defendant, as a nonprofit organization that sponsors professional golf tournaments. Pretty simple. B, that the PGA establishes rules for its golf tournaments, and further, it gets to the point of the rule in question, the PGA rule requiring golfers to walk the course and not use carts. C, identifies the plaintiff, Casey Martin, as a professional golfer who suffers from an illness that limits his ability to walk, and D, when he petitioned to use a golf cart during golf tournaments, the PGA refused, citing their rule, and E, that Martin then sued the PGA, alleging discrimination against a disabled individual in violation of the 1990 Americans with Disabilities Act, which is a federal law. Now we begin the IRAC process, and we start with the issue. It's very brief. Does the Americans with Disabilities Act require the PGA to accommodate Martin by permitting him to use a golf course while playing in PGA tournaments? Next is the rule. The Americans with Disabilities Act requires employers to make reasonable accommodations to persons with disabilities where such rule does not cause an undue burden on the employer. Just as we saw with the key facts, the analysis stage of the IRAC case briefing process is as brief as possible, but still gathers up all the essential information. And again, bullet points are the standard way of doing this. So, in this particular case, we see that the Supreme Court held that Martin was in fact disabled, and he was covered by the ADA Act. Golf courses are public accommodations covered by the Act. That the use of golf carts is not a fundamental character of the game of golf. And that other than the PGA rule, there is no rule of golf that forbids the use of golf carts. It goes on, it's impossible to guarantee that all players in golf will play under exactly the same conditions, so allowing Martin to use a golf cart does not give him an undue advantage over other golfers. F, Martin, because of his disease, will probably suffer more fatigue playing golf using a golf cart than other golfers will suffer without using a cart. G, that the PGA's walking rule is only peripheral to the game of golf and not a fundamental part of golf. And finally, allowing Martin to use a golf cart will not fundamentally alter the PGA's highest level professional golf tournaments. The conclusion is very succinct. It says the Supreme Court held the PGA must allow Martin to use a golf cart when competing in PGA golf tournaments, and the word affirmed, meaning that the court agreed with the lower court ruling in the initial case that held in favor of Martin. Now, when I say brief, that's exactly what we mean, and here's kind of the breakdown for you. The maximum verbiage that you should be using, the case name, citation in court, you should be able to do within 50 words or less. Your key facts, about 150 words. The issue, only about 50 words. Rule of law, about the same. The analysis, up to 250 words. And the conclusion, again, only about 50 words, a total of 600 words. The example we just showed you, if you count everything up, it comes out to just over 300 words. And with that, you should be ready to tackle your first writing assignment. Now, I've heard from several students who have not yet obtained their textbooks. The assignments remain due as scheduled, but I will be flexible this week with those of you who are without a text and unable to borrow a copy. When you turn in your assignment, whenever you can, make sure you include a brief mention as to why it was late. All right, some other things. You have two other items to attend to this week. On the My Peak eLearning course site, click on the discussion forum link and participate in the 2 discussion threads that have been created. You should respond to those threads rather than creating your own. The first one is an introduction of yourself, and the other, a discussion on the fairness of the law case in Chapter 1, involving a law that once limited women to working only 10 hours a day or less. An interesting law indeed. Now, there are questions posed in the opening post of that thread that you should respond to. They're the same questions you'll find in the discussion in the textbook itself. So it'll be helpful for you to be able to look through the case and some of the background material in the chapter. All right. And important note, all students are expected to publish at least 1 post in each thread. So make sure you get in there and do that. Final bit of housekeeping. There's a 112 Business 210 online course orientation class. It's set up by our online librarian in the Richland Center, and it's designed for students who have never taken an online course before. If you haven't, that would be a really good idea for you to go through. It'll just help you navigate things a lot easier. If you're an old hand at it, you might still consider taking it, because all who complete the course will be collecting some extra credit points, and extra credit is always a good thing. Am I right? All right. If you have any questions or concerns, be sure to email me. Next week, the Constitution and some other bits out of some of the basic beginnings of how our law grew from the beginning of the constitutional era in our country. That'll be next week. Have a great week, and we will talk to you then.